Hello and welcome to Fiddling with Trademarks with experienced attorney Travis Richins. My name is Kevin Rosenquist, and thank you for being here today to talk about trademark law and intellectual property, also referred to on this podcast as IP. Travis, great to see you again.
Nice to be here again.
We're going to do some trademark essentials today. So what qualifies for a trademark?
Typically, you're thinking of names and logos. So somebody's brand. There are other things like colors and sounds, things like that. But it's something that associates a good or a service with the source of that good or service.
So what key steps should individuals or businesses take to prepare for pursuing trademark registration?
So, and even if you're thinking at this stage, hey, maybe I never want to register, I think these are steps that companies should take. And it helps them not just with potential trademark issues down the road, but I think with marketing. So, and there are things that companies do intuitively that I think will help them with trademarking. So one is choose a distinctive name and logo. So something unique, something that sets you apart. If you choose something that's too similar to a known brand or even to some other registered brand, then that's where you can run into trouble. And that can give you not just trademark trouble, but I think most companies, they like to have a distinctive brand because they want to have a good quality product or service that their customers associate with. And they're like, okay, when I see that name, it means quality to me. And if it's too similar to somebody else's, and say that somebody else is not so great at what they do, right? Then you could be associating yourself with somebody you don't want to be associated with. So I'd say,
good point. I wouldn't have thought of that, but that makes a lot of sense.
Yeah. So the very first thing is choose a name, choose a logo, choose branding that sets you apart and is distinct. And then as part of that is to do a trademark search. And even if you're just a local company, I would do a federal trademark search. And you can kind of do that on your own. And then you can hire an attorney to do a comprehensive trademark search to make sure that you're not interfering, infringing with, you're not too similar to some other mark. It's a whole lot easier to do that at the outset than when you're 10 years into your business.
And go back and change. Yeah. The last episode, you gave that example of that one company who knew about it, but didn't think it was a big deal. And then all of a sudden it became a big deal because the other company expanded across the country.
Right. And, and I mentioned there that so implicit in what I'm saying, even if you're just local, you can only get federal trademark protection if you're doing what's called interstate commerce. And all that means is you're doing business across state lines. But that could mean that somebody's coming, to you across state lines. So there's a lot of ways that you could qualify for interstate commerce. So some companies, they'll think, hey, I don't qualify for interstate commerce, so why should I bother with a federal trademark search? But the answer is just like the example we gave last time is, well, there might be a registered mark that does qualify for federal protection where they have the exclusive right to use that name in your territory. And you don't want to find that out late.
No, that's especially depending on what you do, that could be a massive rebrand.
Right.
Yeah. Obviously you can just do this on your own online, like a business owner can do it.
Right.
How does working with an attorney provide advantages versus doing it on your own online?
So, well, and I'll give myself as an example. I hired somebody years ago before I did intellectual property law and before I did trademark law. I was an attorney and I was doing a business with my brother, and we hired another attorney to do the trademark. And there were a couple of reasons we did that. I could have figured it out and done it on my own. Sure. It wasn't worth my time because what we paid him was lower than what my hourly rate is, right? So I think a lot of business owners find themselves in that situation. They're wearing, and I talked about this last episode too, it's like when you're wearing a lot of hats, you have to decide which of those hats aren't worth your time. So trademark might be one of those. So that's one reason. It's just to buy back your time. But another reason is there are nuances. Trademark is not the most complicated area of law. It's meant to be user-friendly for businesses, but there are pitfalls, and you don't know where those are unless you've kind of gone through the reps a few times or you've spent a lot of time doing your homework. So you can go off and honestly, you can file an application without running a search at all, and it might sail through, or you might find yourself a year in and having problems. And I've seen people do that, right? Where they filed it themselves and they got rejections from the examining attorney and they didn't know why. They didn't know what to do about it. And then it got abandoned and then they're feeling guilty. And, so it's really just, it's a delegation, I think is the biggest reason, is find somebody who they know where the pitfalls are. they can handle this for you. They can take it off your plate.
What are some of the most common pitfalls that you see?
So likelihood of confusion is the most common reason for getting a mark rejected, assuming it's like markable on its face, like it's trademarkable on its face. And that just means there's somebody out there that's using something similar. And a lot of people assume it's like URLs and websites. We also mentioned this in the last episode. But I've talked to multiple people, business owners, who are like, yeah, I'm good. I've got the website and I've got the business entity, so I'm good. And I'm like, well, and I could run a quick search and say, there's several companies that have this, very similar name. You might have a problem. And they're like, oh, what if I just change the spelling a little bit? And I had to explain, no, because when you're looking at likelihood of confusion, they look at phonetic, they look at commercial impression, and that includes what it sounds like. So you can't just fiddle with it. You can't just tinker with the name and then avoid a likelihood of confusion. That's the most common issue I see. Another one is just, they come up so often that these are all things we've mentioned before, is that they choose a name that's just on its face, not trademarkable. So that happens a lot. So one woman I work with, and her son, he has, I'm not going to say the name of the company, but she's got a young son who had done a project for school and it turned into a business, and he decided, I want to do this. And he changed the name. He went, I said, oh, have you guys looked at that? And she's like, yeah, he was aware of another product similar to his that had this name. So he changed his name to this, this, and this. And he made it distinctive enough, right?
Okay.
He was not thinking trademarks. What he was thinking was, I don't want my product confused with this other product. Right. So if you think that way, if you just think, I don't want this confused with that other thing, you're probably going to guide yourself right, at least on the distinctiveness of your name.
Okay.
And he had done a great job. I was like, that's pretty awesome.
Yeah, I was like, wait, whoa.
Yeah, he's a 12-year-old trademark attorney and entrepreneur. I'm like super proud of him.
Seriously? Wow. Yeah. Impressive. Very, very impressive. How can you help to improve the chances of securing trademark protection that might, what can you do that you can't get when you're trying to do it on your own?
So most commonly I start answering those questions like, is it trademarkable on its face? Right. So I help people avoid that pitfall. That's a really easy, you do a consult and you avoid that in the first 30 minutes of the consult.
Yep.
Then we do a comprehensive search, and we search all federal and state marks, and then the internet, right? Everything that's out there where people haven't registered at all. And we look for, where there might be likelihood of confusion. So basically what we're doing is trying to preview what the examining attorney at the trademark office will do. What happens is you'll file your application. Right now, there's like an 8-month wait before the trademark office will pick it up. A specific person at the trademark office will pick up your application, and they're going to run a comprehensive search. They'll get it. They'll look at it. They'll look at it on its face to make sure it's not Kevin's Diner, right? Mm-hmm. And then if it is, they'll say, hey, Kevin's Diner, you got a problem. But assuming you pass that first hurdle, then the next thing they're going to do is they're going to craft a search with search terms to try to figure out everything that's out there, and then come and tell you if they think that you're too similar to something else.
Okay.
So what an attorney will do is replicate that process on the front end. Hopefully a year before, the examining attorney at the trademark office does it.
Wow, that's 8 months. It's a long time. I guess. Yeah. Should be surprised, but
they got flooded, and they got flooded with applications, and some from out of the country, and just couldn't staff up fast enough.
Yeah, right? I couldn't get the staff. Sure.
That's why they're behind. Now, the application, the search, having an attorney do it for you can get that search done in a couple of weeks, the preview, and get the application filed. And it's just like a week or 2 or 3-week process, depending on the attorney. And you've got it on file. Now it's a waiting game, but you've at least done the preview, and you've got it on file, and you've done what you can to protect yourself. And you can start using your mark. You actually have to start using it before you can get it registered. You have to prove to the trademark office that you're using that mark.
That you're actually using it. Oh, that's good. That's a good thing. Instead of people just hoarding, like people do with websites, where they
not parking on
website
them
domains and then sell them for obscene amounts of money.
Or you've seen that happen with some of these social media influencers. They'll get something really popular, and then somebody will run out and try to park on the mark.
Yes. I talked to someone about that recently. I can't remember what it was, but it was
the Jules LeBron. I think it was So Demure, So Mindful, or something.
So Demure,
like that.
So Mindful. Yeah. Something like that. Yeah, that was it.
Yeah. So somebody ran out and tried to park on that. And I haven't looked at her application. I'm sure what'll happen is she went out and got some legal counsel, and they're saying, okay, it's first to use. Now you have to be using it in association with some sort of good or service. So they would have to go and argue how she was using that with a specific good or service in their application. But if she was first to use, then she may have some priority to the person who ran off to file it. And hopefully she would,
Yeah, hopefully she would. I'm just trying to think
like she definitely has public opinion in her favor. They want her to get the benefit of popularizing that phrase.
Absolutely. But yeah, you're right. If it's not really a good or a service. I guess the service you could be a little bit.
I think social media influencers, they can be providing services. So I think that on that line, there are 45 classes of goods or services, international classes of goods or services. So it's 1 through 45. Any good or service you provide will fall into one of those categories. And when you apply for a trademark, you indicate which class you want to be in. And I'm thinking I'm not very familiar with her and everything she did, but I think she was probably providing some sort of good or service that she might be able to argue is associated with her phrase.
Like entertainment and media, something like that.
Yeah, and maybe she had sponsors. I don't know if she had sponsors. So, but she had to be using it in connection with that good or service. So did she use that catchphrase in connection with sponsorships? Those are going to be the kind of questions.
Yeah. That's an interesting one to see play out for sure.
But the answer is, you saw it very emotionally from her, why you do it early, right? Why it's better to start your, get your trademark protection early.
I don't think I would have even thought of that though for something.
Oh, even thought to do it?
Yeah, not in that situation. I've hosted podcasts and I've gotten trademarks on the podcasts, but I've never something like that. It just was kind of random. I don't know.
Right. Probably because it's what's the good or service connected to it?
Right. Exactly. Yeah. What do you think, in your opinion and experience, what characteristics make a trademark robust, memorable, while still being legally defensible?
So it doesn't even have to be in my experience. So because very helpfully, the Trademark Office has given us 5 categories of distinctiveness of marks.
Oh, is that the 5 we talked about last time?
Yeah. So we talked about those last time. I'll rattle them off. And I like how to make an acronym in my head. I'm like, FAST. Good. Right. It's not the best acronym.
What is it?
Fanciful, arbitrary, suggestive, descriptive, and generic. Descriptive and generic are not trademarkable.
Okay.
So it needs to be, preferably you want it to be fanciful or arbitrary, but it can be suggestive. And we talked about that last time. It's you came up with a good, Kevin's Grub Hub, right?
Yeah.
So, or Grub.
Kevin's Grub House.
Not Grub
Grub Hub might be a problem.
It might be a problem. Grub House might be a problem too, Kevin. We haven't run a knockout.
Yeah, we've got a lot of work to do.
We got to jump on the Trademark Office's website.
I got to tell you, I know nothing about running a diner either. There's all sorts of problems with this.
Oh, we got more problems than the trademark.
Yep. Okay. We got a lot of problems. Okay. I screw up omelets all the time.
It's those, and the idea is don't name. If you want trademark protection, then do not name your Mexican restaurant Mexican restaurant.
Right.
That's the bottom line. Now, I would say
tacos and margs. Probably.
Yeah. I think it's good for business to make it fanciful and arbitrary anyway. I think that sets you apart. So do what's good for business and it's going to be good for trademarks.
Do you have any examples of difference between fanciful and arbitrary?
Ooh, okay. So let's take made up words like Google.
That's fanciful?
Maybe.
Yeah.
Like the line between fanciful and arbitrary, and I don't care very much because either of them are going to get protected.
They're both great. Yeah.
Yeah, they're both so good. It's fine. But yeah, and there's probably a legal distinction that I haven't focused very much on because I don't care.
If it doesn't sound like it really matters, but
no, but it's like Apple might be a good arbitrary example, maybe Apple computers. So it's arbitrary to connect apples to computers.
Right.
But Google is made up. Apple's not a made up word. It's just an arbitrary connection.
That makes sense.
Google's, I think my 9-year-old told me Google is a word.
I think it is now. Yeah. Which makes sense.
Yeah. So maybe Uber is Uber a word? Was that a word before?
Yeah. Uber's a word. Uber, someone is Uber successful.
Or Uber this or Uber that. Yeah. But fanciful would be I think a made up word is a good example of fanciful. And then arbitrary would be, it may be a word, but the connection to your good or service is completely arbitrary. It's not not even your diner example, right? It's if we did Kevin's, what would we call it again? Kevin's Grub House.
Grub House.
Kevin's Grub House.
This thing sells itself.
It's a news outlet.
Right.
That's maybe arbitrary.
That's pretty arbitrary. Yeah. Kevin's Diner is a.
But think about it. Don't you think it's more fun to call a news outlet Kevin's Grub House? than
Yeah.
than to call a diner Kevin's Grub House. You know?
Yeah. No, that makes a lot of sense. That really does make sense. And like, so you brought up something. So when you said Uber, it made me think of Lyft.
Mhm.
And so Lyft uses a Y instead of an I. And is that just their way of becoming a little more noticeable, or do you think they had to do that?
This could be in the prosecution history that I haven't looked at, but changing spelling that won't normally help you if what you're trying to do is avoid confusion, right? So if there was somebody else that had a similar name, changing it to Y would not have helped them. But I think you're more asking, did they need to use the Y so that it was like suggestive instead of descriptive or generic?
Right. I mean, Lyft is sort of a very casual way. Can I get a lift? You know,
yeah, because Lyft they could have been a moving company, right?
Yeah, or elevator company,
or an elevator company, or forklift company. So that's a really good example of suggestive. And I think if they had called it LIFT, like I don't think that would have made a difference in the descriptiveness analysis, probably. Okay. Like maybe a little bit, right? Like in your mind, and what the bottom line question is the consumer impression. And, based on that, I'm like, well, maybe LYFT has a slightly more arbitrary impression in my mind, right?
Yeah.
But it's still like, you're like, well, it's Lyft. I know what it is.
I know what it is. Yeah. But a lot of companies do that though. They mess with especially in the tech world, they mess with the spellings to maybe just be a little more noticeable.
Yeah. To be a little more unique. And I think that's probably a branding and marketing decision. And I think it's a smart one. Like in my mind, I like LYFT, for my Uber competitor better than LIFT.
Agreed. We've talked about a few brands. Are there any notable trademark cases or legal disasters that highlight the importance of proper trademark protection?
So there's one, and actually a friend told me about this. I wasn't aware of it. And he runs a company, and he had been talking to a trademark attorney. He's like, my attorney told me about Whataburger. So have you ever been to Whataburger?
It's a southern one, right? Like southeast?
Yeah, there's tons of them in Texas. So, and I lived in Texas for a long time, and a bunch of Whataburgers in Texas. So any Texan.
I don't think I've ever been to one, but I certainly know of it.
Yeah. So like there's a Whataburger in Virginia that started, they claim, in the 1950s. Okay. So in 1950s, Whataburger, it's like with hyphens, like what a dash burger, right? Whereas the Texas Whataburger is Whataburger. So Whataburger in Virginia they claim in the 1950s, they start selling hamburgers. In the 1970s, and then like in 1957, the Texas Whataburger got their federal trademark registration, which gives them exclusive rights to use the name Whataburger. And by the way, I didn't say it, but they're both hamburger joints. Yeah. Okay. So
figured
it's not a news agency.
Yeah.
So like they're both selling burgers.
Yeah.
And Whataburger in Texas gets the federal registration in 1957. And then in the 1970s, somebody from the Whataburger in Texas stumbled on the Whataburger in Virginia, and they talked to them. And then I think maybe there was some discussion of possible licensing and that sort of thing. And that all fizzled out. And then like 30 years later, they resume conversations, or somebody says, hey, we think there's a problem here. Something prompts the Virginia Whataburger to file a lawsuit. And they filed something. I try to avoid legalese here, but they filed something in the court asking for a declaratory judgment. And that's all they're doing is, usually when you sue somebody, you're like asking for money, or you're asking the court to force somebody to do something. Here, they went to the court and they just said, tell us if we're infringing. That's what they want. They just wanted the court to declare whether they were infringing on the Texas Whataburger mark. Right. Mm-hmm. And so then Whataburger countersued, but I don't think they countersued for infringement. And so then anyway, the district court says that, hey, the Virginia Whataburger had been here for so long, and you, Texas Whataburger, you knew about this in the 1970s and you didn't do anything about it then. So you waited too long. Too bad. Whataburger in Virginia gets to use the name in Virginia. They have the exclusive rights in Virginia, and Texas, Whataburger, you can have your federal mark, registry for everywhere else, right? So it gets carved out. Now, when my friend told me about the story, I assumed what happened was that the Virginia Whataburger proved that they were here first, because the U.S. is a first in use, right? Mm-hmm. So they proved, hey, look, we've been running Whataburger in Virginia since 1950, and the Texas one didn't have the mark until 1957. U.S. is a first in use, so we get the first use. Right now, but if you rely on first use, it's going to limit you to your geographic area. So I assumed that was the case, but I looked at the case and they lost that argument And they lost that argument because they didn't have enough evidence to show that they were using it before the Texas Whataburger got their mark.
Really? Huh.
Yeah. So one of these is rolling the dice is not a plan, right? So the Virginia Whataburger, like we're using it. So if anybody comes along, we can say we were using it first. That's not a good plan because that requires a court case, which is way more expensive than a trademark registration. So the Whataburger in Virginia, they could have saved themselves a lot of money. Like this case went up because the district court actually said, well, you didn't prove that you were using it first, but we're going to say that the Texas, Whataburger, they were too late in asking, right? Well, they took that up to the Fourth Circuit, so they appealed that. And then a year later, the Fourth Circuit said, no. We're not going to look at the 1970 date. That didn't matter because back then there was no infringement. Like Whataburger in Texas hadn't moved into Virginia. And so there was no real dispute. So they weren't too late. They filed suit soon after there was like an actual dispute between the companies. Everybody lost in this.
Yeah.
At the end of the day, there's no Whataburger. There's no national franchise Whataburger in Virginia, right? And the Whataburger in Virginia ended up in 2 years of lawsuits. And they could have been saved. The Whataburger in Virginia could have been saved if they really were in business in the 1950s. Then just register your mark. You would have beat the other you would be the national Whataburger.
You would be the Whataburger, yeah.
Yeah. On the other side, nowadays, like the national Whataburger could have been using like a monitoring service, a trademark watch service, and they could have been aware, or done like a national search online and things like that, and they would have found this sooner than 10 years, 13 years later.
Yeah.
But back then, I think probably the national chain was doing all their due diligence, and they just they just didn't stumble upon it until later.
Boy, it would be annoying to work at that Virginia one. Have to explain that they're not the Whataburger from Texas.
We're not the Whataburger from Texas.
We're not the one every single day.
But there's still a Virginia Whataburger. It's just not your Texas one.
It's not the Texas one. Yeah. All right. Well, thanks for listening to Fiddling with Trademarks with experienced attorney Travis Richins. If you want to connect with Travis, look him up on LinkedIn or visit richinslawfirm.com. And don't forget to like and subscribe and stay up on all things trademarks. Travis, always great to see you. Thanks again.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.